was actually a very interesting experience, and it was a very successful one for me. It was a bit of challenge to give the student an understanding of the EU competition system and the Brazilian competition system in 5 days. And then when I started, I saw that they're actually very much interested in the topic. And I tried to do a comparison between the EU and the Brazilian competition legal system. And I think it was successful, and now it's my last day. I can see that it took lots of success in a way. So what I'm trying to do is to talk about the competition legal system, which is mainly the cartel, abuse of dominance, and the mergers. I try to give them the most important concepts within the EU legal system. And I did a comparison between this and the equivalent in the Brazilian legal system. And I was really lucky because we're giving the course after the reform of the law in Brazil. So that was interesting because, for instance, if I give you an example about mergers, the merger regulations in the past in Brazil, it was based on pre-notification to the cases, to the post-notification to the cases. And now, after the reform of 2011, it started to be a pre-notification of the cases, which is very similar to the EU. So, for instance, yesterday I was giving them the procedure system of under the EU law, and then I had a guest working as a manager for a Brazilian cement company, and she was giving them the feedback about that in Brazil. Very good. It is important because for two reasons. First, the EU jurisdiction is quite old. So we're talking that the treaty started in 1957. So this is a very solid system. And when you're looking to emerging or new jurisdiction that wants to adopt the law, they look to whether the EU system or the US system. So these are the major systems in the world, okay? So that's why I thought that the EU would be interesting for Brazil. And when I dig down and I looked at the Brazilian law system, I saw that there are lots of resemblance. There are some differences, but there are lots of resemblance. And I will give you an example of that. And second, personally, I am interested in competition law in developing countries and in new jurisdiction. And I wrote recently a paper about how developing countries, they tailor the law. And I discovered that some of them, they just cut and paste from different jurisdictions, and some of them, they just conceptualize. So they take a concept and try to adopt it to their system. And some of them, they just do some regulations from scratch, which is actually coming from their own system. And Brazil is a very interesting case because they actually took some concepts from the EU and conceptualize it to be very similar and to fit in their economic system. So that's the main reasons, basically, why I chose between these comparisons. And to be more specific, for instance, the example I gave you earlier about mergers, I was involved in one of the studies that happened in the OECD, and we were looking at the Brazilian competition law, and that was in 2010, so that was before the reform. And one of the recommendations we had is to reform their merger system because it's very important for such a country to have a reform. And they reformed their system to be very much similar to the EU, which is the prior notification to the merger. So in another way, to make things simple. So before the merger happens, they have to notify CADE in that sense, which is the competition authority in Brazil, before the merger is happening. And this is very useful than just notifying CADE after the merger is happening, and the damage can be done because it can be harmful to competition. I think contrast is a big word, and the similarity, let's focus on the similarity first before talking about the contracts. One of the similarity is that between the EU competition law and the Brazilian competition law is that both systems, they have a kind of a framework in their laws. So it's not, so they give examples, so it's non-exclusionary examples instead of just having a very specific rules to a very specific act. The example of that is Article 101 and Article 102, for instance, in the TFEU treaty. And the equivalent of that is Article 36, which encompasses the anti-restriction regulations against competition in Brazil. And so these are examples of behaviors that might harm competition rather than being specific rules that has to be adopted. So this is the real similarities. And if we're talking about the real differences, I would say one is the abuse of dominance. I think the abuse of dominance position in the EU is more extensive, and they have more of cases, and they worked on it extensively. And that actually is different than in Brazil, because in Brazil the competition policy is actually focusing on cartel and on merger rather than abuse of dominance. So that's one of the differences. The other differences is to have in mind the experience of the EU vis-a-vis the experience of Brazil in relation to competition law. So the EU has, we're talking about more than 50 years experience, and Brazil is starting. But we have to admit that in the EU, we look at Brazil in relation to cartel rules like one of the really leading jurisdiction in that matter, especially they just started in the 90s. Well, today we're going to talk about mergers rules. So yesterday we talked about jurisdictions, and today we're talking mainly about the substantive analysis, and I'm bringing to that the Ryanair case, which is an interesting case that shows a lot how the EU is changing their way they are analyzing the mergers from a dominant position base to more of a significantly impeding effective competition. And I'm also inviting one of the professors. He's actually a professor in Sao Paulo, but most importantly, he was working in CADE, and he's bringing a case from Brazil to make such a comparison to the student. And in relation to cartel, there are so many cases that I actually focus on from the EU, and I try to focus on the vitamins case because it actually has. They have a vitamin case here in Brazil. So we were trying to see how it is similar when we are defining the markets. This is the same thing when we're doing it here in Brazil. It's very similar to the EU. What is market power? How can we just detect cartel? The leniency program, which is very successful here in Brazil, and how it is in a way similar to the one of the EU.